Hi, welcome to MACast, our podcast for conversation and information on legal and non-legal stuff. Today we are going to talk about the art of advocacy. I'm Matheus Aimoré Carreteiro. I'm found partner at MAC Advogados, and we have here today a very special guest, Harry Burnett. Harry has lots of experience in the field. He has been working in the field of international arbitration and international disputes for many, many years. He is the head of the Brazilian desk at King Spalding, which is basically the number one firm of GAR, Global Arbitration Review, and the number one firm of chambers and partners for so many years. And I have known Harry for virtually 20 years or almost 20 years. And we're going to have a really nice conversation today. I have learned a lot from Harry. He's a mentor and a friend. And we want here today to share some insights and his perspective in the art of advocacy with you guys. So, Harry, muito obrigado por estar aqui.
Não, é um prazer, Matheus, estar aqui com você, especialmente com seu novo escritório, muito de qualidade super altíssimo. E agradeço a oportunidade para estar aqui com você hoje para bater um papo sobre o arbitragem internacional e meus perspectivas de certos tópicos, né?
Muito bom, muito bom. Let's start a little bit. Let's start with the beginning, right? I want to know first, and I think it's interesting to know, how did you get involved with international disputes and international arbitration? How everything began?
Well, I always had a love for Latin America. I speak Spanish and Portuguese, so I was always going to different events, Brazilian American Chamber, Colombian American Chamber, Peruvian Business Council. I didn't really know why I was going. I just wanted to go and be part of that. And then the first case I had was with you, and I met someone who we used to work with, Pedro Maciel, and you guys had a case. It was in New York. It was in English. It was under New York law, and the client was a Brazilian client and did not speak English at all. And that was a great experience. I mean, we all worked very hard, had a good outcome, did Pedro and you did cross examinations, and that was when I saw the cross cultural aspects of being able to try cases and work on cases. Because before I had done a lot of domestic arbitration, some very big ones where you have to be away from home for a long period of time. But once I got to the taste of cross-cultural international cases, I said, this is it. This is what I'm going to do.
Exactly. So basically, when you graduated law school, you wanted to do already arbitration, or it was more, I want to try case, I want to be a litigator? Do you remember how it worked?
Yeah, so I started out as a prosecutor in New York.
Okay.
To be totally frank, I'm not sure I really understood arbitration or what international arbitration even was, but I was able to use my Spanish, and then I tried a lot of cases, jury trials, and became comfortable in front of judges, and then that led to commercial litigation, and then ultimately, international cases.
And when you first started involved with international arbitration, what was the most impacting difference that you realized? I mean, you said, I don't want to do domestic arbitration or domestic litigation anymore. And there's something different here that really call your attention.
for me, since most of my work is in Latin America and a lot in Brazil, it it's just more profound for me. The relationships with co-counsel, the language aspects of the case, the cultural aspects to, I mean, that underpin the cases and the relationships between the parties from different countries. And I just found that to be fascinating. It was easy to jump in like to a swimming pool and just say, this is great, and this is what I want to do. And I kind of really haven't looked back with any regret whatsoever.
And do you think that language and culture comes together when you are involved in international disputes, or you can have them in separate buckets?
I personally think that um, language is key. And, I was a Spanish major in college, and then I've been married to a Brazilian for 30 years. So my Portuguese is not quite as strong as my Spanish. I feel like I learned in the Rua a little bit. But I think that the relationships with the witnesses who speak another language, relationship with co-counsel who, speak both languages like you very well. I think it gives you a leg up as opposed to really not speaking any language involved in the case.
And talking about culture, I know that it's different having an American client and having a client from Latin America, right? From our perspective, it is, but I want to know your perspective and and of course, how do you see those different advantages, disadvantages, or it's not really advantage and disadvantage, just a different animal or different thing, and how do you handle that?
That's a very good question. So, U.S. clients based or non, yeah, I guess U.S. based clients, um, a lot of times they're not familiar with the legal system that their arbitration's in, and so you really need to hold their hand. And sometimes they're in the arbitrations in Portuguese, or sometimes it's in Spanish, and the in-house lawyer doesn't speak, and so you have to kind of tell them what's going on and explain very carefully. Latin American clients, I think the relationship might be slightly more informal, but not in a bad way, in a good way. It's just, especially if you speak Portuguese or Spanish and you've got a client from the region. I think that it's slightly more informal, but they're equally as gratifying.
And I know that you have been involved in so many commercial case and investment disputes, right? Do you see any difference? And perhaps you, considering that in Brazil we don't have investment arbitration, we all our case are commercial disputes, right? If you could talk a little bit about what is investment arbitration and how you see a difference between these two words, or if you don't see any difference at all, I think your perspective would be interesting to hear.
There actually is a big difference in investor state cases. In very basic terms, you have two countries that have a treaty with one another, and they, under the treaty, they provide protections to investors from the other country. And if they're mistreated, or if their investments expropriated, or they're taxed out of existence, or just fundamentally treated unfairly, you can bring a claim under the treaty against the sovereign, and either in the UNCITRAL rules or ICSID, which is part of the World Bank. And against cases against states are very unique because they're harder to settle, because the government officials don't want to stick their neck out and sign an agreement to pay money, because they're often nervous that the next administration will come in and all of a sudden the Controlaria will be knocking on their door. So they often go to hearing. Commercial cases, I think, tend to settle more. And also the investor state cases tend to take a longer time because the states in general, but I think this is true, try to drag everything out and make the case last as long as possible. And there's a lot of delay tactics employed by the states, and it's very hard to extract information, even though you've got document requests. The state is always like, oh, we don't have those documents, and so that it can be tricky in that sense. Commercial cases, I think, are generally quicker because it's just pure business, one business against another business. And they're both, to me, very interesting. Like a shareholder dispute or, a general commercial dispute, I think will generally go faster, and you
Mhm.
won't have a lot of the same concerns by your counterparty. They're a business partner and they want this thing over, and they're going to fight you and you're going to fight them, and you may settle or you may not settle, but they are different animals for sure. And I think the ISDS cases, the investor state cases, I think are becoming a little less common. I think
Okay.
there's kind of a slight downturn in those.
And when you, what kind of tip you could give to a client before getting into a dispute, or what aspect you think a client should pay attention when when everything is a honeymoon, right? When everything is going well, they are still negotiating a contract, or they are analyzing a potential investment in a place based on your experience. What kind of uh, tip you would give to a client?
I mean, I think, for example, if you're doing an investment in Latin America for a U.S. client, you really need to have great co-counsel, local counsel. You have to understand the cultural nuances of, where the other side's coming from vis-a-vis you. And I think that, and this is corny because it's been for years and years, people talk about the midnight clause, like everybody's the honeymoon, and then they just slap in a arbitration clause, and it really needs to be carefully thought out. And I've tried to work with my corporate partners, and they're very good to call me and say, look, here's the clause, or we need a clause. And you don't necessarily, for example, want to seat the arbitration in the country of your counterparty, especially if they're politically connected or super wealthy counterparty, because then you're going to be subjected to the courts of the other party, and that can often cause a lot of problems, which I've experienced firsthand, as you know.
Yeah, yeah. Tell me a little bit more about this. I mean, how the political environment or your counterparty should be considering in the overall negotiation. How do you see uh, the fact that the parties have to paying special attention to certain aspects during this negotiation or before they start a litigation based on your experience?
Well, I do think that you need to try to get a neutral place,
Okay.
because just use like use Peru for an example. If you have a Peruvian counterparty and the arbitration seated in Peru, and I'm not picking on Peru, I'm just using it as an example,
Sure.
you'll often end up with local administrative proceedings, local tax proceedings, local bankruptcy proceedings, local criminal proceedings, and so if your counterparty is part of that world, is from that country, they often have influence internally. So you want to neutralize that as much as possible, and have a seat like in New York or London, or although I will say there are seats in Latin America, in Sao Paulo, for example. If there's not that imbalance between the parties, Sao Paulo is a great place to seat an arbitration. In Brazil, generally, the quality of the lawyers, the quality of the institutions. I was just at the CAM CCBC conference, and I've been very impressed by them. I got my first appointment as an arbitrator with that institution, and so, um, but I think it's, you really need to take a step back and a deep breath. And if the corporate lawyer, for example, doesn't know the cultural and nuances or the other legal system, then they need to find somebody at the firm who does and sit down and talk it through with them.
And let me ask you a question, because you have lots of experience in Latin America, and you are an expert in Brazil, and I would say in Latin America in general. But I know that you also have experience in Europe and Asia, and of course in the US. Do you see any difference between arbitrating or litigating case here versus the rest of the world? Do you see any special or different aspect that should be taken into consideration?
Definitely. I really haven't done many cases in Asia, but United States, um, the cases I think tend to be more structured and, kind of not a lot of procedural room to um, be super creative from a procedural standpoint. In Brazil, and you and I experienced this firsthand, and I learned through you and through others that if you've got a Brazilian tribunal, it may very well look like a Brazil, even though it's international, it may look like a Brazilian proceeding. And I was very shocked when we started talking about witness statements, and the tribunal was like, well, wait a minute, we might not even have witness statements. And I almost fell off my chair and had to really argue to get witness statements. Or I think that in Latin America, the arbitrators sometimes have little patience for long cross examinations, like we experienced. And
Yeah, of course.
I was criticized a little bit, but I said, look, I cut this down to 25% of what I was going to do, so give me a break. And then also there's some procedural idiosyncrasies. For example, we had a case. The case was over, and my counterparty said, "Oh, they put in a legal expert, and now I want to put one in." And I was like, "The case is over. We just had closings." And they let him put it in, which I don't think would ever happen in the United States, and probably not in Europe. So you got to really have good co-counsel like you to prepare yourself for
And
things like that.
and you have to be perhaps a little bit more flexible, right? To
Yeah.
understand that some things are under your control and some are not. And based on that, what do you think? How do you see when you work as? And I know that sometimes you are work as an arbitrator. I know that most of your expertise or what you really like to do is to try case and be a lawyer, represent clients. That's why this is a podcast about the art of advocacy. But I know that you have experience as arbitrator as well.
Mhm.
How do you see being an arbitrator as a complement to what you do as a lawyer? You see as something that you just do uh, not frequently? How do you see the role of arbitrators and being an arbitrator and being a lawyer in case?
Well, like at any time, I'll be sitting in maybe 3 cases or 4 cases because it's difficult due to conflicts at a firm of our size. But I enjoy doing it, and I think it helps you understand. I've sat with a lot of really great arbitrators, and so you get a feeling for how they think, right? And that helps you as an advocate. And I think also, and lawyers are very conservative in this sense, but you've got 10 arguments, 3 of them are really good, 4 are okay, and then others are not so hot. I think some lawyers feel like they've got to say everything, and because if they don't, then the client will be upset or whatever. But I think it's really important to go with your absolute strongest arguments, and you can cover the other ones, but you've got to triage your positions to put forth the strongest case, because otherwise things get diluted if you're trying to make all 10 points. When I was a young lawyer um, in New York, in the New York Supreme Court, which is our trial court, my mentor said, "Kid, you're going to be in front of this particular judge. He's going to give you 3 minutes. Just get your top three things out, your top three arguments out, and then he's going to cut you off." And I think that there's a lot of sense to that. And I had a case where Doak Bishop, my partner, this was many years ago before we were partners, obviously, and I was arguing before him, and I was doing a cross examination, and I was kind of probably going overboard with a particular witness and maybe beating him up a little bit. And Doak was the chair, and he said, "Mr. Burnett, I think the tribunal, I think you've made your point. You can continue if you want to, but and that signals you to just stop. Some lawyers are
Exactly.
cabeza dura and they just keep going and going, but you need to read the tribunal, and if they're looking at you like, okay, we get it, um, then you just need to kind of move on."
Exactly. And you just mentioned a very interesting point about having 3 minutes to pitch your case. Do you think this also an art of advocacy to be able to pitch your case in 3 minutes, and sometimes people like spend 20 minutes when they should speak only 3 minutes? Is that a thing, real thing?
I think so. I mean, I think you need to make all your arguments as persuasively as possible, but I also think it's good to try to boil things down to their essence. And this is sounds kind of corny, but sometimes I go home and I I explain a case to my wife, right? And she's very smart, but she's not a lawyer. And if she doesn't get it, I try to do it again, and then she says, "Okay, now I get it," and that helps me kind of um, I don't know, center myself a little bit on the most important points. And it's surprising some of the things she kind of picks up on that I think, okay, well, I better not use that.
Elena
But
is very smart. I know that.
it's just tough.
Exactly, as it's supposed to be, right?
100%.
As arbitrators are. So I think, and talking about having a speech of 20 minutes against 3 minutes, how do you see the pace of disputes nowadays? You think they are as fast as they should be? You think they are still is lower than it should be? How do you see that from an international perspective nowadays?
Well, that's a great question, because I think investor state cases still tend to drag out for the reasons that I discussed earlier. I think commercial cases I think there's a lot of criticism of arbitration that, okay, it's not that fast and it's super expensive. And I think there's a trend to try to get it back on track to have those attributes that make it attractive in the first place. But a lot of it depends on the tribunal, and a lot of it depends on your counterparty negotiating a procedural order that everybody can live with, but that's quick. And then I think tribunals need to really sometimes, put the hammer down on, bad behavior or excessive document requests or things like that. And I think arbitrators are getting a little more willing to do that than before, because I think before there was a fear that, oh my God, the award's going to be annulled if I tell them they, can't call a certain witness that is going to say exactly the same thing as the one that just testified. But I think the trend is, and I think that's good for all of us, to make it a little more streamlined.
And this is one special quality that people have to look for when they are searching for an arbitrator. I mean, someone who has the courage to say, "Stop it! I already got what I wanted to know, and just move on." or you think this type of personality it's hard to deal with and people should avoid? How do you see that?
Well, for me, it's important that the arbitrator you select is somebody you respect and somebody who has a backbone and will, make sure to listen carefully, roll up their sleeves. I think maybe the most important person, I'm sure you agree, is the president. And you have to kind of dig down and say, how long is it going to take this person to do the first draft of the award? I've had
Exactly.
people do it, turn something around in 90 days. I've had someone take 2 years.
Wow.
Uh, and so that's very important because it can be the clients get super frustrated if it drags on and on. So the picking of the right arbitrators is really an art form that you can't just like pick somebody you've heard of, that has a good reputation. You really need to talk to your team and let's talk this out and look at their experience. And there's a lot of public data on arbitrators. You can, see what they've done. A lot of them sit in both kinds of cases. So you have investor state cases that you can actually read and how did they come out on this issue or that issue. And especially if there's a contract investor state arbitration, which is more similar to a commercial case,
Commercial, yes. And when you are basically analyzing or deciding arbitrators to pick, how important diversity is when you are performing an assessment on that from your perspective and from the client's perspective. Do you see a huge difference between uh, tribunals when you have diversity or not?
Uh, that's that's a good question. I mean, we generally just try to get the best tribunal we possibly can. And I have a big case where it's three women, and we had the hearing. It was fantastic, and then there was a group photo of because there's many many people in the room, so all the women took a picture with the three women arbitrators because it was not a common thing at the time.
Nice.
And I just think it's the quality of the arbitrator. Diversity, yeah, I think is important, but there's so many good women arbitrators that, and that's what I consider diversity is, really putting women on tribunals and giving them an opportunity, which obviously has been a little bit slow in our business, but there's so many unbelievably smart and tough and quick arbitrators. So um, I think it's important. Sometimes it's important to the client too, right? And you have to kind of balance that against, the is this the right arbitrator? And you're not picking
Exactly.
someone just because of their, race, creed, color, religion, or sex.
Exactly. And you have been involved in so many high stake arbitrations, and they have something different, right? When you in a very high stake case. But I have the feeling that sometimes smaller cases always give you the same type of work. It's not that you have $1 billion case and you have a $500 million case. That the $500 million case will give you half of the work. In my experience, sometimes it's exactly the same hours that you have to do to invest in both cases. How do you manage that in practice with your team, with the client's expectations for fees and costs in general? How does that play in practice?
I think as a practical matter, everybody likes the huge case where, the client is they're not fee sensitive because there's so much at stake, and the in-house lawyers and even the executives feel under pressure, and they're like, okay, let's just send the army in and do whatever we have to do, as opposed to some of the smaller cases where there's a lot of competition to get the case, and sometimes you have a budget that is uh, very restrictive, and so you have to, as a lawyer, decide how you're going to handle the case. And we always handle the case as best we can, but you don't throw everything you can at it. You know, you've got to be very selective in who's working on the case, how many witnesses you have, what and why, how many experts you have and why. And the smaller cases, and we've had some ourselves, are just as fun. A lot of times they're faster, but you know, law firms are in a business to make money. So, in a sense, so you can't um, throw half the firm at a case that's a $10 million case. You know, you've got to really think smart about how to handle it.
Exactly. And in terms of having the best people, and I know that King Spalding has the best people in the team. The international arbitration practice has many talent partners, brilliant people. How do you handle so many egos together? Because of course they are bright, but you also have to deal with egos. People they want to feel that they are heard. They want to feel that they are the ones leading the case. How do you do that? Because it's a really tricky part of of handling a successful team, right?
It is tricky, and thank you for the compliment. I mean, we do have a lot of great lawyers. You were actually part of the team when you worked at King and Spalding, and you're a very high quality lawyer. And many of our visiting foreign lawyers are just amazing and work hard. But as far as managing egos, I think we've done a pretty good job at the way that we try to get cases. Is we band together and hunt in packs, and you know, if I have an opportunity, I'll call two or three other partners. It doesn't matter what office they're in, that have the experience and the expertise, and then you get the case, and you know, you all work on it equally, and share the credit, share the win, share the loss. And that doesn't mean that every now and then there's not some, you know, ego issue that arises, but I think it's rare with our, you know, because people don't like demand to lead the case, because it's more of a broad-based leadership on every case.
More cooperative. And do you think artificial intelligence will make disputes in general and perhaps international arbitration cheaper and faster?
You're probably asking the wrong person, but I do use it. I think there are benefits to it. Some of our arbitral institutions, even like the ICDR, have AI tools that can help you summarize procedural history of a case, which is, you know, not exactly the most stimulating work, you know, but it has to be in the award. And as far as, you know, I personally worry about somebody relying too much on AI. There have been cases in the United States, and probably here too, where lawyers have been sanctioned for like fake cases. You know, they use AI, they're under the gun, they slap a name of a case in and say it says this, and the judge says, well, wait a minute, you know, I had my clerk go check, and that case doesn't even exist, or it doesn't say what you're saying. And so I think there are some benefits to it, but it's also, I think, a little bit, you got to manage it properly.
Exactly. It needs to be extremely well supervised, right?
Yeah.
What you're doing. And let me talk about political scenario.
Okay.
United States, of course, you are there. You know how things are changing fast. And I don't want to talk about politics, but political scenario, and in Latin America as well, right?
Right.
Right, left, all of that. How do you see all these political change impacting dispute resolution in general? A very broad question, so we can, because you have a lot of experience and you have been doing this for a while. Is that normal? What we have today is different from what you had before. How do you see that?
Well, first of all, things are changing so quickly, you know, especially in Latin America. One year you've got a a left-leaning leader, and then the next year you've got a right-leaning leader. We obviously have our own leader who I take the trade war, if you will, as an example with China and with others. He doesn't like arbitration. He just likes to get an agreement with someone and put as much pressure as he possibly can on the other party to kind of consent to his agreement on tariffs and stuff. And I think, in the USMCA has watered down dispute resolution provisions. But I think in a sense, if you've got a leader that's erratic, or a leader or there's constant turnover in the cabinet, people are making big decisions about infrastructure projects or different aspects of the government and how to deal with foreign investors. I think that can increase the number of investor state cases, for example. I think that's the biggest impact.
Instability means disputes.
Yeah.
Yeah.
It means bad decision making, or someone's been named minister of mines, and then 2 weeks later it's another person, and then they make a decision, and then they're replaced, and that decision was not good. It's I think it complicates things when you've got instability in the ranks of the governments and constantly replacing government officials.
Exactly. And having good lawyers avoid disputes, or they increase disputes? What your take on that?
I mean, good lawyers get the client out of the problem as fast as they can. And there's a quote by Abraham Lincoln, but I don't remember it verbatim, but it's basically like, cases will come and go, but a good lawyer is somebody that, helps the client resolve their problem as quickly as possible, because that you'll get more work, but that's your overall objective, is to, accomplish the client's commercial objectives. And you see sometimes in the business, some people that are kind of dragging things out, or they don't want something to settle. And my view is try to find the silver bullet as soon as possible. And
Exactly. How do you deal with that? That's a good question. When you have as opposing counsel someone that clearly wants to keep the ball rolling and the people fighting, and you see a good opportunity to settle the case, to end the war, end the fight. How do you deal with that?
well, I mean, sometimes you need to expose this to the tribunal, who sometimes you see it, and sometimes, strangely enough, the tribunal doesn't really see what's going on. But I find it sometimes helpful to actually have the principals talk to each other. If the relationship isn't so destroyed that there's, at a high level of the leadership within the company, there's a relationship sometimes, and this is not always, sometimes risky, but sometimes you just put them in a room without the lawyers, and they come out and they're like, okay, we're done.
Yeah, it takes a lot of experience to know when is the right moment for that, right? Because sometimes if you try to do something like this in the wrong moment, things can get only worse.
That's true.
And let me ask a question. Having been involved in the arbitration or dispute resolution community for a while, what do you enjoy the most? What's for you really the nicest thing about this community? And this is a good tip for young lawyers as well, right?
Yeah, I guess for me, it's the teamwork and the team concept, and the stimulation you get when you're in a hearing, and I think it's important to give different lawyers roles in the case, speaking roles, if they're ready to handle it, part of the opening, or get them cross a witness. And if it's a more junior lawyer, maybe, but you have a lot of faith in them, they can cross maybe a less um, significant witness, for example. And that generates like loyalty, that generates excitement, um, for everybody on the team. And I think that that's what I like the best. I've run across lawyers that they try to do everything, and kind of like everyone's just feeding them stuff. And I don't think that works very well, especially in a big case, because you can't really master every little sub issue in every case.
Exactly.
But if you've got a great associate or a great junior partner, say, okay, you take this, you take this, you take this, and that makes them invested, and
And
they don't mind eating Chinese food at 2 o'clock in the morning because they're excited about what they're doing.
exactly. And this is part of being a great leader, right? Having or finding the or getting the best from each person from the team, right? And I think this is something that I have experienced that you do extremely well. How do you see that?
Well, I should ask you that because you're also the same. You engender a lot of loyalty among your colleagues and partners, and the junior lawyers feel like their voice is heard, and that's all very important. I don't know whether it has anything to do with it, but when I was 13, my father sent me to military school for reasons we don't have to go into. And it taught me kind of the chain of command. You start as a private, and then you're a corporal, and then you're a sergeant, and then you're a staff sergeant, and then you're a lieutenant, and I think that that mentality can help organize the teams. And I don't want to sound like I'm a military fanatic, but I think that structuring the team appropriately, but also having like an open door policy. I tell lawyers all the time, like, I don't care what the question is, come in and ask me. I don't want you to feel like you're going to bother me, or, I mean, I want to know what's on your mind. And if I give you an assignment, communicate with me. Don't disappear, and then you come back and you give me something. And if we had had a conversation, it would have been kind of more what I was looking for. So I think communication is super important.
Super important. And you have we can see that you have a huge passion for what you do, right? You really love trying case, arbitrating case, and how it works. I mean, where it comes from.
Well, I don't want to denigrate other areas of the law, but I think we're very lucky to have, and I kind of just fell into it and then said, oh my God, this is a world that I want to live in. And that's it. I mean, I think what we do is so fascinating. If you're intellectually curious about different cultures and different legal systems, and our team is super cross-cultural, and that excites me. Now, I've had excitement prosecuting a case or trying a case in court, but I love what we do, and I think we're very fortunate. I think about that all the time. That, like, thank God we had that first case together, because it opened my eyes to a whole nother world that I
Nice,
wasn't familiar with.
nice. And I learned a lot from that case. And I mean, years go by, and we still see things happening today that we experienced 20 years ago, right? And it helps when you are in a hard position, in a hard case, and you have to decide if you're going to go left or right within seconds. And getting all this experience from you, I want you to tell me two things for us to finish this podcast, this conversation. The first one, what's the best tip, advice you got from a mentor or someone?
That's it, to be kind of flexible depending on who you're before, right? And this is kind of a lesson that I used to work for a very well-known litigator, tough guy in New York, and I grew up in Brooklyn, went to Columbia Law School, but kind of a hard ass, and he was a great guy. And we had a case in Geneva in front of like a Spaniard, a Frenchman, and a Swiss arbitrator. And I remember telling him, or like, very early in the morning, we were working across. I said, remember, we've got a Frenchman, a Swiss guy, and a Spaniard or a German. I can't remember exactly. This is not like 60 Center Street, downtown Manhattan, with it's like rough and tumble. These are kind of, and he looked at me, he's like, kid, I know who I'm talking to. And then he proceeded to do an amazing job, his cross examinations. And I had the chair of that tribunal come up to me at an event and say, that was, incredible watching him do that. Others, will come in like a bull in a china shop and upset the tribunal. So that I learned that from him. It wasn't direct advice, but it was me I was worried that he was going to be too harsh, and
Okay.
but he had the sensibility to read the tribunal.
Okay. And what's the best advice you could give to someone starting a career in international arbitration or international disputes, or someone who looks at you and say, ah, I want to do the same. I want to be this guy in the future.
I don't know who'd want to do that, but
I certainly do.
I don't know. Well, I'd say learn the nuts and bolts early on. Do whatever. I mean, you're not going to just waltz in to sit at the first chair or the second chair in an arbitration. It takes a long time, and it takes a long time to build relationships. Like I think we talked about earlier, I've been to Brazil 70 times, Peru 35 times, Colombia 25. Just over years, you kind of accumulate the relationships, but you have to realize that you need to start, like, to use kind of an analogy, like getting the coffee, and then you kind of work your way up, because then you've built the base of knowledge from the kind of most mundane thing to the most sophisticated and everything in between.
Exactly. And thank you. Obrigado por ter participado, Harry. Foi um prazer.
Um prazer. Total meu.
And stay tuned, stay connected, subscribe to our channels. We have more interesting podcasts like this one to come. Thank you for your time and your attention. See you soon.